All rise. Court is reconvened. You may be seated. Calling civil motion calendar number 2, civil number 11-1-1731, Dr. Orly Taitz versus Loretta Fuddy et al. For 1, emergency motion request for the court to docket amended motion for rehearing, which was received by the clerk of court on 11/21/11 by certified mail but never docketed and never given to the judge. And 2, amended emergency motion for rehearing. Appearances, please.
Your Honor, Orly Taitz, plaintiff.
Good morning, Your Honor. Jill Nagamine and Rebecca Quinn, Deputies Attorney General representing Loretta Fuddy.
We have here before the court the motion for rehearing. I believe you are filing it pursuant to Rule 60, Hawaii Rules of Civil Procedure. Is that correct?
Yes, Your Honor.
All right. Argument on the motion.
Yes, Your Honor. This case was originally dismissed based on Hawaiian Statute 338-18-9. And
well, just for clarification, the original petition cited 3 grounds. One was for mandamus, one was for agency, which the court actually was not really an agency, but the court allowed you, gave you certain latitude to frame it in terms of an agency appeal. Another grounds you cited was 92F.
Yes.
Correct? And so you're here on a motion for rehearing on the court's granting the motion to dismiss. Is that correct?
Yes, Your Honor.
Go ahead.
The motion to dismiss was granted based on basically one statute, HRS 338-18. With my reply to the opposition, I have also filed a request for judicial notice and also a motion for reciprocal subpoena enforcement.
I believe we have scheduled the motion sometime in the latter part of January.
Your Honor, this is an urgent matter because it is related to a trial that is set for January 26th in the state of Georgia, where I...
But it's not before the court. The only thing that's before the court is a motion for rehearing.
Your Honor, but if this is an emergency matter specifically requested in my pleadings, and I'm requesting now, I'm moving the court to allow me to argue this urgent matter because we have trial coming January 26th in Atlanta, Georgia. The judge have ordered Mr. Obama to stand trial. The judge has already denied his motion his motion to dismiss and the 12B motion, and therefore we are now in discovery. We have less than 3 weeks before trial.
When you appear before this court, the court requires that all parties, including attorneys, licensed attorneys, pro hac vice, as well as pro se litigants, abide by Hawaii's court rules. Not only the circuit court rules, but the Hawaii Rules of Civil Procedure. The court does not make exceptions, and what is here before the court on a proper motion, the court is considering your motion. It is a motion for rehearing pursuant to Rule 60, Hawaii Rules of Civil Procedure, which you have cited to.
Your Honor, in my reply, even if you refuse to...
Not refuse, you have a scheduled hearing date.
Your Honor, it's going to be pointless in the end of January after trial. What is the point of having a hearing after trial?
The court cannot help you in that regard. There are certain motions, there are certain rules that allow you to shorten time. You have filed a motion in the regular course.
I have filed an emergency motion. And there are exigent circumstances.
Well, you have not cited to the proper rule. The court cannot give you the legal advice as to what rule to cite to, how to properly phrase your motion, because the court cannot be an advocate for one side or the other. So the court is here on your motion for rehearing, which was properly scheduled, properly filed and allow the state to file an opposition and for you to file any reply memo.
Okay, even if you disregard the emergency motion to provide reciprocal subpoena enforcement within the reply to the opposition, I have included a subpoena which represents an order from the court of competent jurisdiction.
The reply memo is intended to reply to an opposition, not to inject new matters.
Your Honor, this is not a new matter. In my amended motion, I have stated that I am an attorney who is representing plaintiffs in multiple challenges.
The court has spoken. The court is allowing you to argue under Rule 60 as to your motion for rehearing, as to the order granting the motion to dismiss pursuant to Rule 60.
Which I'm doing, Your Honor. Pursuant to Rule 60, I'm allowed to bring new evidence, which I'm doing. I am providing new evidence showing there are challenges to Mr. Obama's eligibility in all 50 states of the nation. We have a trial coming. I have included a subpoena with my reply to opposition to show that according to this subpoena, this is a court of competent jurisdiction. This is an administrative court of the state of Georgia.
Objection, Your Honor. The information Ms. Taitz is citing right now was not in her original motion. She may have cited something to this in her opposition or in her reply to our opposition. This was not in her motion. It's improper for her to be making this argument right now. I would ask the court to make her stop.
Is it in your original motion?
It could not be in the original motion because this is something that came only recently.
Okay. Knowing that the court has read everything that has been submitted with respect to the motion before the court, if you could succinctly, not to repeat your argument, but to summarize the same, and then I'll turn it to the AG for their opposition.
Okay, even if Your Honor is refusing to give any credence to the fact that there is a subpoena from which is a valid subpoena for the defendant to provide evidence. I have provided in my motion information and argument that indeed such challenges are being filed in multiple states. I'm currently representing plaintiffs in multiple states. Just recently, Ninth Circuit Court of Appeals have ruled that the presidential candidates have standing to challenge. Multiple courts have ruled that voters have standing to challenge. In those cases, be it in Georgia on January 26th or be it in other states, there is a need to provide evidence in those challenges. And according to the state of Hawaii, according to best evidence rules, according to state of Hawaii rule 91-10-2 and Article 10 rule 1002, what is provided by Mr. Obama does not represent best evidence, and it cannot be used anywhere around the country. It is just a copy that he posted on the internet, which is deemed to be a forgery based on statements of multiple experts. According to best evidence rules, in light of this forgery, there is a need to examine the original document. Moreover, during the ruling after October 12th hearing was made based on representation by Ms. Nagamini, where she stated in the state of Hawaii, when the records are requested, the answer is yes or no answer. Yes, we have it on file. No, we don't have it on file. This was a complete fraud. There is no such rule in the state of Hawaii, nowhere. It was something that Ms. Nagamini just made up in order to cover up for and allow this forgery to stand. And for that, Rule 60B includes not only new matter, but it also includes evidence of fraud and misrepresentation, which would allow reconsideration. And therefore, I respectfully state that because improper rule was quoted, rule that doesn't exist in the state of Hawaii, rule that was just made up by Ms. Nagamini, this is sufficient reason for reconsideration in the motion to dismiss. I would also, if Your Honor refuses to allow me to introduce the subpoena from the state of Georgia, I would ask for a continuance so that I can properly present this court with an emergency motion which contains a subpoena from the state of Georgia, whereby, according to such subpoena signed by the Deputy Chief Judge of the state of Georgia, Ms. Fadi is ordered to appear at trial and pretrial deposition and provide documents in question. If Your Honor is not willing to rule on this today, then I'm asking for continuance so that this matter can be heard in conjunction with this subpoena that came from the state of Georgia, and in conjunction with the order by the Deputy Chief Judge of the Administrative Court of Georgia, which states that the case is going to trial. Thank
Ms.
you.
Nagamini, who wishes to argue?
Thank you, Your Honor. Frankly, I believe that our argument is adequately presented in writing to the court, but for Ms. Taitz's benefit, I would like to respond to one of her points, since she's been unable to find that law that I was referring to on October 12th. Please allow me to quote from the transcript of that hearing so that we know exactly what I did say, and then I will read the law. And I apologize to the court, because I know the court knows this law.
Opposition, Your Honor.
And I did not interrupt Ms. Taitz when she spoke, so I'd ask her not to do that.
Same courtesy.
At page 27 of the transcript of that hearing, I stated, and I'm quoting, it says, Barack Hussein Obama II, male, born. That's all index information is, and a verification would be if someone says, I have this record here. Was Barack Hussein Obama II here, born in Hawaii? And the answer, the verification, would be yes. Or, do you have a record? Yes. Verification is not somebody coming in and going through agent records that are held in the vault of the Department of Health. Verification is yes or no. Do you have it? Don't you have it? That's all it is. That was what I just read from the transcript. That's what I said at the hearing. Ms. Taitz has said that she's looked in the rules of evidence for that, but that's not where she should have been looking. She ought to have been looking a page earlier from 338.18, because when she said she went to the library to find 338.18, had she turned the page previous to that, she would have found 338-14.3, which reads in relevant part, subject to 338.18, the department, upon request, shall furnish to any applicant, in lieu of the issuance of a certified copy, a verification of the existence of a certificate and any other information that the applicant provides to be verified relating to the vital event that pertains to the certificate. I'll concede the words in the statute don't say yes or no, but I think that verifying the existence of something is the same as yes or no. So I'm certainly sorry that Ms. Taitz didn't understand what I was saying, but that is the law that I have absolutely not made up. I would like to just make a couple other points. The original matter that we were here for, just to simplify this, Ms. Taitz she claimed that she was bringing her petition for a writ of mandamus. The court ruled that there was no place for that here and dismissed it on that ground. The court also dismissed it on the ground that there was no agency appeal that was being appealed from, and the court was going beyond an agency appeal and treating the petition as a complaint and found no basis upon which to grant plaintiff the relief she sought.
And to reiterate, in terms of the complaint that which relief she sought under 92F, which is nomenclature UIPA, under the 92F with respect to the Uniform Information Practices Act, in terms of what she received from Dr. Onaka, O-N-A-K-E, that's on or about by letter dated May 19, 2011, in which he stated, state law prohibits the department from disclosing any vital statistics records or information contained in such records unless a requester has a direct and tangible interest in the record or is otherwise allowed by statute or administrative rule. And direct and tangible interest is defined and determined by Chapter 338, and the court hereby affirmed his denial of the request. So the court also dealt with Chapter 92F in that regard.
So I think the simple matter here, Your Honor, is there any newly discovered evidence that changes that?
And also to reiterate, under Chapter 91, in allowing the state to also argue under agency appeal, under Chapter 91, there are particular definitions with respect to agency hearing contested case. Contested case means a proceeding in which the legal rights, duties, or privileges of specific parties are required by law to be determined after an opportunity for agency hearing. Also, agency hearing is also specifically defined, refers only to such hearing held by an agency immediately prior to a judicial review of a contested case as provided in Section 91-14. The court allowed Ms. Taitz to argue agency appeal under Chapter 91-14, and the court will reiterate that in terms of under the Chapter 92F UIPA, in which she was denied access, in which Mr. Onaka did respond to her request, that does not constitute an agency hearing.
Thank you, Your Honor. So my final point is that plaintiff's claims have been meritless from the beginning, and she continues them. And I hope that this court is willing to put a stop to this. I noticed that the court has scheduled something on enforcement of the plaintiff's Georgia subpoena later this month. But I think in light of the fact that this case was dismissed, this court is not a forum to enforce a Georgia subpoena. And even if this case weren't dismissed, I don't think this is a court that is a forum to enforce a Georgia subpoena. So I would ask this court to continue with its original dismissal, uphold that, deny Ms. Taitz's amended emergency urgent motion for rehearing. I'm sorry I had that title wrong. And I would ask the court to make a finding that Ms. Taitz's claims are frivolous and that they are intended to waste our time, the court's time, and judicial resources, and grant me leave to file a motion for attorney's fees as a sanction to Ms. Taitz. Thank you.
Ms. Taitz, brief reply in terms of the opposition.
Yes, Your Honor. First of all, I was not allowed to bring anything new to this hearing. Why would the court allow Ms. Nagamini to state a rule? She just now brought Rule 338-14.
I believe she's responding to your oral argument in terms of that Ms. Nagamini improperly and or fraudulently or may have made certain misrepresentations regarding a particular rule.
But
So she was responding to your argument.
Well, that's an improper time to bring forward a new rule. She had an opportunity to include it in her opposition.
For your information, I'm not considering the argument. The court is looking at in terms of whether or not there's any exhibits, affidavits, declarations, and attached to either the moving papers, the opposition, or the reply memo. Argument is intended to persuade the court one way or the other, but it is not evidence.
I also bring to Your Honor a point in response to what Ms. Nagamini stated in regards to verification. Even if you were to include Rule 338-14...
Are you addressing her argument? Because you just asked the court to disregard her argument.
What I am stating is, Your Honor, that as a matter of fact, I'm reiterating that verification has to be done based on...
Ms. Taitz, in terms of your argument regarding, or your reply regarding verification, that's responding to Ms. Nagamini's response to your rule, and then she responded in kind. So are you responding in kind to her argument regarding the verification?
If Your Honor is...
and I'm saying I'm disregarding
Okay,
that.
then I'm responding to what Your Honor has quoted in regards to agency appeal. I have stated in my motion that I specifically went to the health department. There is no specific rule for agency hearing. As I have submitted a request for information, it was denied in a letter by Mr. Onaka. I have asked for a hearing and I got no response. There is no other hearing that is routinely done by the health department. And I have argued in my position that what was done indeed constitutes a hearing.
The court disagrees because if you look at Chapter 92F under the UIPA, there are particular provisions under Chapter 92F that deals with judicial review, that deals with requests being made under Chapter 92F. So there are different mechanisms under either Chapter 91 or Chapter 92F. It's dealt with differently.
Your Honor, as I stated, I have provided information that what mechanisms. There is no specific mechanism described, and what Ms. Nagamini was supposed to state, what was there within my request for agency appeal that was not proper, that was not according to the rules, and there is nothing. She just stated this was not a hearing. Based on what? There is no evidence. There is no argument showing why my request for information and denial of my request and my request for appeal within the agency that was ignored does not represent an agency hearing whereby I was aggrieved, my request was denied, and based on that I was entitled to seek redress in court. Now, in regards to I was not even notified when is it scheduled. Your Honor, may I ask on what day is it scheduled, the hearing on my motion, my emergency motion?
January 26th.
Your Honor, I specifically stated in my motion that the trial is scheduled for January 26th. I am respectfully asking to expedite the hearing.
The court cannot entertain oral requests to expedite. You need to follow the proper rules and the proper motion.
Okay, Your Honor, then I will file. I would ask for the court to allow...
the court can only entertain whatever motion is found with the court.
Okay, as I stated, I'm just asking for continuance, and I'm asking to just give me an opportunity to file a written request to expedite, specifically because the trial is set for January 26th, on that very day. I also would like to state, in response to what Ms. Nagamini has stated, in sanctions. I believe that sanctions should be applied against the defendants and their attorney. There was no justification for not allowing review of the documents. Your Honor, I would like to remind you that when I have submitted this appeal, all at the same time in my pleadings it stated that there was a subpoena served from the federal court. So there was a subpoena then. Now there is a new subpoena from the state of Georgia. There are other cases coming for hearings, and there will be subpoenas from other states. Just as Your Honor would expect subpoenas from this court to be ordered and provided full faith and credit in the state of Georgia and in other states under reciprocal subpoena enforcement. I would argue that the same would be expected of this court. Ms. Nagamini arrogantly, absolutely arrogantly, is claiming that this is frivolous. Your Honor, how is it frivolous? The evidence that a person sitting in the White House and who wants to sit in the White House for 4 more years is using a forged birth certificate according to experts and an invalid social security number. How in the world could that be frivolous? It's the most important thing one can imagine. It's just unthinkable. It's just a sign of corruption for somebody to even suggest that this is frivolous.
Well, the issue of frivolous is not before the court, Ms. Taitz. The court is not entertaining any type of finding in that regard.
I understand that the court is not entertaining Ms. Nagamini's request.
Not an oral request. If she intends to file any type of written motion, the court can deal with that such that you can also respond in kind.
I would like to just provide one more argument, Your Honor. What we are doing right now, we are reviewing Hawaii Statute 338-18 in light of what was conceived by the legislature of the state of Hawaii. And this is something that needs to be viewed in balance with constitutional rights of the U.S. citizens, voters, and candidates on the ballot. It is clear that that statute was enacted in order to protect privacy rights of individuals who want those rights to stay private. Mr. Obama has already released the documents, and as a matter of fact, in my reply, I have provided a statement made by his proxy, by his deputy campaign manager, attacking me personally for asking to get this information. This information is relevant and important for each and every voter in this country, for each and every candidate on the ballot. This is information that would show whether we have a legitimate president and whether the person on the ballot is legitimate. When the statutes are twisted, when subpoenas are disregarded, when the civil rights of citizens are disregarded, it's a slippery slope. I come from the state of California, where in 1942, civil rights of 112,000 citizens were disregarded by an executive order, which is memorialized in ex parte and in...
Ms. Taitz, I'm allowing you a broad latitude in raising arguments that were never put forth either in your moving papers or your reply memo.
I did not bring Endo, I did not bring Korematsu v.U.S. However, I did state that this is an issue that is related to civil rights of the U.S. citizens, civil rights to lawful elections free of fraud and forgery. And
Wrap it up, Ms. Taitz.
Yes, and therefore I urge Your Honor to review with utmost importance those civil rights in relation, in balance to what is claimed by the state of Hawaii. As I state, if it needs to be done in writing, I will file today a motion to expedite the motion for reciprocal enforcement of the subpoena, in light of the fact that January 26th is the date of trial, and I question why was it scheduled for January 26th, where it specifically stated there that this is the date for trial. I urge Your Honor to please take into consideration that the state of Hawaii provided zero legal or factual or moral grounds to show why the document in question should not be provided, should not be examined in light of best evidence rule, as it was already made public by the individual whose document it is. There are no factual, there are no legal, there are no moral grounds. And on the other hand, when you balance the civil rights of 311 million American citizens, though those greatly outweigh any considerations, frankly non-existent, that the defendant has provided. The only consideration the defendant has is to cover up forgery. And I would like to remind Your Honor that during Watergate, fraud and...
Ms. Taitz, Watergate was never mentioned in either your moving papers or your reply memo.
It was,
also.
Yes, it was, Your Honor.
It's referenced, but then remember now, this is a Rule 60B motion.
Okay.
Okay?
Thank you, Your Honor.
Watergate is not new evidence.
Yes, Your Honor.
All right, the court is denying the motion. Ms. Nagamini, prepare the order accordingly. Court stands in recess.
Your Honor, I have a question. Based on her motion being denied, does that mean any further hearings in this matter are set aside? Since the matter is dismissed?
Well, let's see what your order says.
Okay.